remember all of the things that I thought I wanted to be. Hello everyone, welcome to Law Sessions with Kara. I am Elizabeth Gabriel. In this session, I'll be talking about the concept of the law of contract, particularly defining what a contract is, the essential elements of a valid contract, how a valid contract can be formed. As lawyers and law students, we are encouraged to always refer to sources. By sources, I mean experts, academics in this area of law, judicial precedents, legislations, that is what a particular act says about something. Treitel, in his book, The Law of Contract, 5th edition, defined a contract as a promise or set of promise which the law will enforce. Toby JCA also defined a contract as an agreement between two or more parties which create reciprocal legal obligation to do or not to do a particular thing. From these definitions, you will see, or you can say, a contract is an agreement between two or more persons which will or can be enforced in law. Under the English law, the basic elements of a contract are the agreement, which consists of offer and acceptance. At this point, there's an offeror and there's an offeree. Offeror is the person making the offer, while the offeree is the person accepting this offer. And there's a presence of consensus ad idem, that is, the meeting of the minds between the offeror and the offeree. And there's also consideration, intention to enter into legal relations, and some authors will also add capacity to contract. There are some agreements which would have the presence of offer, acceptance, consideration, but would lack intention to be legally bound by the agreements. Examples of such agreements are social or domestic agreements. For example, A makes an offer to B to go out for lunch, and A tells B that when we get out there to eat, I'm going to pay for the drinks while you're going to pay for the food. B accepts this offer and they go out. When they get there, A pays for the drinks and B refuses to pay for the food. There's offer, there's acceptance, and A has furnished consideration by paying for the drinks. But there is no contract, so it cannot be enforced in law. Other types of agreements that cannot be enforced in law are agreements that are contrary to public policy or illegal agreements. For example, a certain man by name Evans comes to me and tells me to let one bedroom in my house to him to keep someone against the person's will. Note that this would amount to kidnapping. And he tells me that after 3 months, he's going to pay me the sum of 1 million naira. I agree. And he keeps the person there. And after 3 months, he comes, takes the person away, and refuses to pay me my money. That agreement is an illegal agreement, so it cannot be enforced in law. On the domestic front, that is, agreements or arrangements between a father and his son, a mother and her daughter, or between a husband and wife. For example, in the case of Spellman versus Spellman, where the husband promised to buy his wife a car to strengthen their strained relationship, he entered into a hire purchase agreement for this car, and the car was delivered to their house. When he failed to transfer the car to his wife, the wife went to court to make him enforce the promise. The court held that it was merely a domestic arrangement and therefore it cannot be enforced in law. This agreement, that is social, domestic, illegal agreements that are against public policy, are all presumed under the law not to have the force of law. That is, they cannot be enforced in law. But there are exceptions, and I'll be treating these exceptions in subsequent sessions. Also, the court will not enforce certain agreements which lack consideration, but there are exceptions to this, and I'll be looking at it shortly. The importance of contract cannot be overemphasized. Contract has covered virtually all aspects of human activities, ranging from agency, partnership, sales of goods, the company, hire purchase. And the law seeks to enforce certain agreements in order to bring about order, peace, tranquility, and the efficient running of the commerce, economy, and various industries in our countries. The legal relation covered by the law of contract is to assist a person who a promise has been made to enforce this promise in the court of law, and also seek for remedies when there is a breach of this promise. A contract can be classified into formal and simple contracts, bilateral and unilateral contracts, express and implied contracts. A formal contract is a contract in writing made by way of deed under a seal, which is signed, sealed, and delivered. And this kind of contract does not need consideration to be proved when there is a breach. I had said earlier that the court would not enforce certain agreements if it is lacking consideration. If the agreement is made by deed under a seal, which is signed, sealed, and delivered, then the court need not ask for consideration to be proved before it can enforce that contract when there is a breach of promise. Simple contracts are contracts that are not made under deed. That is, they are made orally or in writing, and only a party who has furnished consideration can bring the contract to be enforced in the court of law if there is a breach. A contract can be in writing and still be not under a deed. Skinner CB tried to clarify this point in case of Rain vs. Hughes, where he says all contracts in England are classified into agreements by specialty, which are the formal contracts, and agreements by parole, which are the simple contracts, and there is no such other classification as agreements in writing. And he went further to say that if an agreement is in writing and not under deed, consideration must be proved if there is a breach of that agreement. He specifically made this statement to repeal the statement made by Lord Mansfield, who was a judge in the King's Bench, who said that as long as a contract is in writing, consideration need not be proved. So Skinner CB tried to explain this point that a contract can be in writing as long as not on that deed. It must need consideration to be proved if there is a breach, and only the party who has furnished this consideration can bring for the enforcement of this simple contract. Bilateral and unilateral contracts. A bilateral contract has to do with exchange of promise, where the offeror promised to do something in exchange for the offeree promising to do something else. For instance, Davido has a concert and he tells Whiskey that I'm going to give you the sum of 5 million naira if you agree to perform in my concert. Whiskey agrees. So there's an exchange of promise. I will give you 5 million naira, I will perform in your concert. So you see, Whiskey has promised to perform in the concert and Davido has promised to give him 5 million naira. That is the exchange of promise. And this kind of contract will be called a bilateral contract. Unilateral contract. That is the actual performance in exchange for promise that has been made. For instance, Banky has a dog and the dog is missing. He puts out an advertisement and says that and promises to give the sum of 1 million naira to whoever is able to find his dog. Adesua finds the dog and brings it to Banky and says, okay, you said you're going to give the sum of 1 million naira to whoever finds your dog. I have found your dog, so can I have my money? And Banky decides to say no. Adesua can enforce that contract in law because she actually carried out what Banky said should be carried out. That is the finding of the dog, and therefore she's entitled to the 1 million naira. You would see that Adesua's acceptance to find Banky's dog was not communicated to Banky, and therefore the finding of the dog and bringing it to Banky would constitute acceptance and consideration, and Banky is bound by his promise under the law to give Adesua the sum of 1 million naira. In the famous case of Khalil vs. Carbolic Smoke Ball Company, the defendant company, which is Carbolic Smoke Ball Company, advertised in the newspaper to the effect that they're going to give the sum of £100 to anyone who bought their smoke ball, used it for a minimum period of 2 weeks, and still succumbed to influenza. The plaintiff bought one smoke ball and used it in the manner prescribed by the company and still succumbed to influenza. The company were held liable and they were to pay the sum of £100 to the plaintiff. The court held that acceptance needed not to be communicated to the company, and acceptance took the form of performance by the plaintiff by using the smoke ball for 2 weeks and still succumbing to influenza. Performance in this case will also be seen as consideration. From this case, you will see that in a unilateral contract, acceptance need not be communicated to the offeror, that is the person who made the offer. The performance by the offeree, which has accepted it without the notice of the offeror, would now constitute acceptance and consideration, thereby making it a valid contract, because the offeror is bound by law to carry out the promise which he has made to whoever is able to perform what he has said in his offer. Express and implied contracts. Express contracts are contracts in which the terms of the agreements are clearly stated. For example, A advertises for tenders for the construction of a house, and he picks one of these tenders and he awards the contract to the owner of the tender, and the materials needed to carry out this contract or the construction of this house are all clearly stated after there has been negotiation for the price, the duration, and every other thing, and they agree that I'm going to pay you the sum of 10 million naira for the building of this house, 5 million naira is for the materials, and you're going to build this house in a period of 2 years. And after 2 years, the person has not been able to build this house, and that constitutes a breach of the contract. The matter is taken to court, and the terms which were expressly stated will be referred to for the court to say, okay, there has been a breach of the contract made between A and B. Implied contracts. These are contracts which the terms are not clearly stated, and the court will construe through the conduct of the parties, not by their words. For example, A enters into a bus. It is implied or is presumed that for you to enter into a bus, you should have your fare with you to pay, and the bus is to take you to the place you want to go to. So, if the bus is able to take you to where you want to go to, and you're not able to pay your fare, that's a breach of the contract made between you and the owner of the bus. And even if you're able to pay your fare and the boss decides to divert and go to someplace else, he has breached the contract which you entered into. So it's like a silent contract, and the court will be the one to imply that there's a contract between the two parties. In Bergen against Metropolitan Railway Company, the defendant was held bound by a contract, although he did not sign the documents that contained the contract. It was brought in evidence that the parties had been carrying on for a reasonable period of time based on the terms in the unsigned contract. Therefore, the courts now held that the parties had carried out a contract based on the unsigned contract, and the court assumed that the parties had already agreed to the terms of the contract, which was stated in the document of the contract, although it was unsigned by the defendant. By way of recap, I talked about the basic concepts of a contract or the law of contracts. I gave you the several definitions by Professor Tritel and to be JCA, and I also pointed out that a contract happens between two or more persons or parties and it must be enforced by law. I gave you examples of contracts that or agreements that would not be enforced by law, although I say there are exceptions to it, which I will treat in subsequent videos. I also talked about the importance of contract. I talked about the essential elements of contract, which are offer, acceptance, consideration, intention to enter legal relations, capacity to contract. I also talked about the various classifications of contract, where I said the formal and simple contract, that is contract under a deed, and contracts that are not under a deed, which are either oral or in writing. I talked about bilateral and unilateral contracts. Bilateral, the exchange of promise; unilateral, the actual performance for promise. And I talked about express and implied contracts. Express contracts where the terms are clearly stated, implied contracts where the court will construe through the conduct of the parties. I would go further, or I would go into details in talking about the essentials of a contract, which are offer, acceptance, consideration, intention to enter into legal relations, and capacity to contract in subsequent videos. Thank you for watching this video. Like and follow us on Facebook, Instagram, Twitter at LSWK, and subscribe to our YouTube channel at Law Sessions with Kara. I remember all of the things that I thought I wanted to be.